The Juvenile Justice Board in the capital has declared that the sixth accused in the Delhi gang rape case is a minor, which means that a teenager who was said to be the most savage attacker in the gang rape of the 23-year-old girl may get away with just 3 years of correction or reform and no jail. The board said there was no doubt about the boy's birth certificate in his school records. Joining us now from the capital is KTS Tulsi, Senior Advocate, Supreme Court, as well as in our Delhi studios, Dr. Jitendra Nagpal, a Senior Psychiatrist. Just going to Mr. Tulsi first. Mr. Tulsi, I know your position is that this is what the law says in terms of the Juvenile Act, but do you also believe that that should not be changed in any manner?
No, I believe that we need some flexibility in this law because the IPC says that nothing is an offence if it is committed by a child not above the age of 12, not above the age of 7. Between 7 to 12, it depends on the level of maturity and the level of understanding of the person, which is determined with the help of sociologists, psychiatrists, and then only their liability is determined. But suddenly we have, without amending the IPC, we have changed the law and taken it from 16 to 18 so far as Juvenile Justice Act is concerned. There should be compatibility between different laws which are framed on the subject, and it can't just disregard the provision in the IPC. If in 1861 a child of 12 was deemed to be sufficiently mature and understood, have the understanding of the consequences of his actions of committing the crime, over the period of last 150 years, we have only become more advanced. The children are growing up faster, they have access to internet, they are doing much better.
So are you saying that there should be more integration between the different laws, that there should be more unanimity in that sense?
There should be integration, unanimity, and also there should be sufficient flexibility as provided in the IPC. Maybe from 12 you can say 12 to 16. There should be flexibility. There can't be a rigid formula for determining the criminal liability and saying that 18, no matter what is the nature of the crime, no matter what is the level of your understanding.
Sure.
So there should be some flexibility like in other countries.
Right, I get your point there. Just getting in, Dr. Nagpal, are you of the view that it also depends on how brutal the action is and how aware the person is, not necessarily just on the age?
Well, certainly. I think I partly agree with what Sir is saying, Tulsi Sahab. But also, are we forgetting that the social dynamics of adolescents are changing?
That's the point he was also
absolutely
raising.
And within the last span of 20 years, the world has seen a dramatic change. Laws have changed across the world also. And the grey area between 14 and 18 has taken on the maturity of an adult in terms of likabilities, dislikes, hatred, crimes of passion, or maybe rape and murder. So are we keeping in cognizance the developmental context of a human being in the context of adolescence, and then maybe changing the laws in the nation to suit the protection of the society also?
Sure.
We completely appreciate that juvenile justice was required in our country because the amount of sexual abuse.
There should be a second chance for juveniles because...
True, because I agree that if such an offence or second time offenders are there, they obviously need to be monitored. But I am firmly of the opinion that amendment is required because we need to see the criminal responsibility and the intent of a human being at 17 or 18.
So why give a second chance to a juvenile and not an adult?
One, because we agree that the provisions in the Juvenile Act are supposed to be for the care and the protection of the juvenile. But while we are looking at the care and protection of the juvenile under the JJ Act, are we ignoring the protection and the care of the society?
At large.
At large, because that can lead to a chaotic society tomorrow. Who knows, tomorrow a 14-year-old might do the same thing. What are we going to do?
Point taken. Just going to Tonima Biswas now. Tonima, the police have placed that inquiry report before the juvenile board. What is their real position? Because he cannot be charged for murder under the Juvenile Act. How are they going to try and change that?
That's right, Amitabh. What we know is that the police have submitted an inquiry report in front of the Juvenile Justice Board today. And as you were mentioning, the report clearly highlights the role played by the juvenile in this entire gang rape incident. They also say that he was the one who in fact lured both the victims into the bus from that bus stop and inside the bus, which was the scene of the crime. It also says that the juvenile is an equal participant along with all the other 5 accused who are adults in this entire incident. So yes, if the juvenile does get convicted in this case, a maximum as per the Juvenile Justice Act would be 3 years in a correction home. But yes, that also depends on whether he gets convicted and whether the Juvenile Justice Court actually decides to give him the harshest punishment or not. As far as we know, the police have not mentioned anything more than this in the report. They have not said, as we have seen in the case of the charge sheet, that they have asked for a death sentence for the other 5 accused. In this case, nothing like that has been mentioned. But yes, technically he cannot be charged with murder, although the IPC sections, and as I mentioned, the exact role played by the juvenile has been mentioned in this inquiry report, but he cannot be technically charged with murder. So as we have been saying, that what the police has also been telling us right from the beginning is that the juvenile was right at the helm of the affairs on that particular night. He was responsible for some of the most brutal acts in the crime. But the court has decided that his age, as per the school certificate, is 17 years and 6 months, and that's what they're going to go with.
Thanks for that update. Mr. Tulsi, just coming back to you, which side of the fence, if I can put it like that, are you in terms of, is this case, we do know that he was the most brutal, or at least that's the accusation, even if he was a juvenile. Do you think this is a knee-jerk reaction in terms of this particular case, or do you think there is a serious requirement for a rethink just because of this particular case?
No, I agree with your second statement that there is a serious need to rethink because of this case. But of course, nothing that may be done now can affect the criminal liability of a person, because only a law which is in force on the date of the offence can be applied for the purpose of punishment. And if he is a juvenile, and whatever is the Juvenile Justice Act on that day will decide his liability, and not any of the changes that may be made. But I do believe that a change is necessary, because according to the Crime Record Bureau statistics, 65% of the offences amongst the juveniles are committed by those who are between the age of 16 to 18. And if that is the statistic which is staring us in the face, where is the justification to retain the increase in the age?
Right.
The increase in the age may actually make them more vulnerable to be used as pawns by the adult criminals and throw the blame on these children.
Sure. Point taken there. Point taken. I just want to bring up another issue here. Justice J.S. Verma panel report, which has been presented to the Home Ministry and the government. Well, Sunil Prabhu has spoken to Venkaiah Naidu, who's on the parliamentary panel. They are promising that their recommendations will come before the end of the monsoon session. But pointer here, Justice Verma's panel did not recommend, or in fact strongly made a recommendation that there should be no lowering in the age from 18 to 16.
Parliament is likely to meet on around the 20th of February. So another 15-20 days is not a big time. And we make a registration and then we make a deterrent punishment. We must go through all the sides of the issue and then make a perfect law so that it can stand the scrutiny of law. That is the purpose. I want the job to be completed at the earliest. I am also eager because we have seen the outrage among the people in the country about the continuous atrocities committed against our sisters. So I am also eager to complete the task at the earliest and submit the report before the Parliament meets.
So here you have it, a firm commitment there from the chairman in charge of Home Ministry, making it clear that he will submit that report to Parliament before the budget session of Parliament.
Dr. Nagpal, here just again the same question. Is there a knee-jerk reaction from society, death penalty, castration, lower the age just because of this case? Because the Justice Verma panel, which has looked at the whole issue of violence against women, has said that it shouldn't be.
Agreed. So the knee-jerk reaction is obviously justified looking at the sentiments of the nation at large. Sure. But nonetheless, that while we completely abide by the court of law, it is time to deeply introspect on the provisions of the JJ Act, and some provisions need to be flexible to suit the protection and the care of the society at large. That's my one point. Second point is that keep the developmental context of a human being in mind, the context. we know that the content are justified of JJ Act, but the context is of today, 2013, what's happening in the world around us. Otherwise, you see, there is no deterrent as a prevention then. While we agree that education at large, at the school level, at the family level is the long-term weapon, but what about law?
What about law and society at large?
Yes.
Dr. Nagpal and K.T.S. Tulki, thanks so much for joining us on this show tonight.
India's #1 news app just got even better. Download NDTV's new app. Fully optimized for retina display. Full screen view. Faster response time. And Sudoku. NDTV's new iPad app. Download now.